Merci à chacun et chacune.
Thank you. Thank you to all the distinguished keynote speakers who have taken the floor this afternoon, because there is a link between political ethics and trust, and it does come out of those different presentations that although systems are not identical, they can be compared, because most of the time a scandal, the scope of standards, controls and checks are the elements which might be at the origin of all that, although they might be in some cases quite limited. And the efficiency of the different regimes is also of importance. So I think that we have a lot of food for thought, I would say, for the 30 minutes we have left, because this will allow us to have a genuine and very interesting debate on political ethics and trust. If you do have questions, please raise your hand and we will give you a mic so that you can raise potentially your question. But thank you very much for being the first to dive into the debate. Well, that's not really a question, actually, and that's not a question meant for one keynote speaker in particular, I must say. Although I would like to focus on the exposé made by Hugues. I think that there is a link between trust and transparency. Since the very beginning of this meeting, I do believe that people take it for granted that transparency and the practice of transparency is likely to induce some trust. But I would like to be the devil's advocate, if you don't mind. And I wonder if maybe it's not the other way around, or whether it's not the contrary. This morning we did refer to the mother and the babysitter, but let's imagine a couple, for example. And imagine that one of the two in the couple tells his or her partner, well, now I need your code to your smartphone, to your computer, and so on and so forth, because it will induce more trust amongst us. It will be a source of greater trust amongst us. I think that everyone in this room, in the audience, will consider that the answer is no. This type of practice, for the sake of transparency, might arouse, on the contrary, some distrust, I think. Well, that's indeed a way to be slightly provocative, and it brings us back to this famous debate about trust and distrust. I think that what might induce more trust in the institutions and in the staff working for those governing institutions would be the regular possibility to have this feeling of distrust. And I would be on the same page than Martin Laughlin. In a democracy, trust will be related to the fact that we have this possibility to distrust, to challenge some statements, or to disagree with potentially some statements made, and potentially to organize a rally or a demonstration with a view to go against what is put forward. So I would like to introduce into the debate the fact that trust is based on the possibility to enjoy a certain level of distrust, but of course we need to determine when distrust might become a kind of pathology, or might become the expression of populism, for example. That's the point, we need to determine that. But there are probably, and with no doubt, good examples of good practices related to distrust. So it's a matter of trust, distrust, and transparency, and way to articulate the different elements. Sorry for being so long.
So I have a finger rather than a hand, because it's connected. My question is connected to what Professor 𝐒𝐨𝐻𝐚 just said. So there's a recent book, where actually it was a set of lectures by Honora O'Neill, in which she defends this idea that a culture of accountability, not necessarily transparency, but accountability and increased mechanisms of accountability, be they legal or political, actually generate a culture of suspicion rather than a culture of trust. So the suggestion is perhaps our focus should be on trustworthiness and evidence of trustworthiness on the part of institutions or whatever it may be, rather than on trust. And I just wondered whether you had some thoughts on this.
D'autres questions dans la salle ou on peut aussi...
Any further questions in the audience, or we could ask each other questions? Thank you for your presentations. I have a question for Koen, and this is about the last slide of his presentation, where he talked about the system of commerce in the Netherlands. So you were talking about the limitations of the Ethics Commission and a solution that could be found by asking an opinion to experts of ethics. But it would be, if I have misunderstood, tell me, the assembly that would in the end decide whether it's relevant to sanction the given MP. And I would like to know whether, because I've worked on the checking the powers of the assemblies, isn't it the same problem, the same situation when a political majority could somehow rule in favor or against because this or that MP belongs to a certain party? And let's say that the sanction, the parliamentary sanction, would be a bit biased by this political games of majority and opposition. This is something that we find in the checking of powers that was sanctioned at the European Court of Human Rights. Maybe I have a question myself. There was a question here in the back. Thank you. I will ask my question now because it's slightly linked to Lena's question. It's about the checking bodies at the European level, because we understand the issue of self-control, self-checking at the national level because of the centrality of the parliamentary powers. But this principle of parliamentary powers, is it also an obstacle to a third-party control by the EU Parliament? I think that the European Union could be the place where we move away from this catch-22, but there is this self-control, self-checking that is in the issues of ethics. But this is more a question for Hugues and Cecilia. Maybe I can use my privilege of chairwoman to ask a question, and then we'll see whether there's a second round of questions. Maybe this is a question for Eric Buge and others. You mentioned two constitutional models in France, one that is applicable to magistrates who have a duty of maximum exemplarity versus a system that is more flexible and a system of protection even of the political leaders who benefit from a certain immunity. And between these two models, there is a whole set of rules to protect political integrity. So you're saying that this is something that is blocked by the immunity regime. So what was possible for the judges to make their exemplarity duty sacred should also be possible for politicians. And if we really want a public, asserted code of ethics for public affairs, maybe, and it's the same thing in Belgium, we have some soft law rules, binding or not binding, or abiding, but hard to apply. So without ignoring the importance of the separation of powers, but if we make this status constitutional, that would put in comparison separation of power, immunity, and code of ethics that sometimes seem to be contradictory or intentions. And this is probably an issue that can be observed in the UK. And then there, if I have understood, you want to statutarize this to
ministerial code, which would be against the separation of powers as understood in Belgium. At least this is my understanding of the jurisprudence of the Council of States. And so I would like to know how this proposal articulates with the separation of powers as understood in the United Kingdom. Donc le premier salve.
So the first round of question would be this.
Très brièvement sur les deux.
Very briefly for the first two questions, and this is linked to the issue of transparency and the trustworthiness. If I'm not mistaken, there's no French equivalent, really. So I worked on the notion of trust in my PhD, so I have analyzed also the works of Mr. 𝐒𝐨𝐚 that were mentioned this morning. And if I remember well, he defines trust as a mechanism of reducing social complexity facing lack of information. So for me, the issue of transparency is another issue that may not go hand in hand with trust, because transparency makes trust useless. So if we want to increase transparency, this is something you might want to do, but then don't talk about reducing trust. These are two different issues, but I totally agree.
To strengthen trust or confidence, then you need to strengthen trustworthiness, and then you need maybe rules or other elements that give some guarantees about what you are expecting, but not give you the proof that it is respected, because then you don't need trust anymore. So I think it's two different levels of action, and it's very interesting to have that in mind when we work on these topics. Thank you.
Je ne sais pas si on m'entend bien. Ah oui, voilà. Je voudrais
To react to Edouard Delruel's presentation, I would like to mention the ideology of transparency and an instrumental version of transparency. So Rosan Vallon, that I could not mention in my conclusions because I could not read my conclusion, but I had somewhat a hard version. I have a lot of admiration for Rosan Vallon, but he makes a caricature of the European Union, and he reveals the mistrust that many people have to the EU because of their ignorance of what it is. But Rosan Vallon says many interesting things in all of his books, and the distinction he makes between three figures of transparency. The utopia figure of transparency finds its hero in Jean-Jacques Rousseau's philosophical politics. The transparency characterizes immediate relationship with yourself and others, and nothing stands between you and your conscience. So that's the hearts would replace the uncertainty of discussion. So this utopia turns into an ideology when it makes transparency the key value, and always more transparency as the progress of democracy. I quoted Rosan Vallon because I think that this is truly exact. And so transparency is a virtue that is above truth or above the idea of the general interest. the power does not know what to do with it. We only care about what it should be. And we do this in words that come to dreaming about its dissolution. It's not about limiting powers, but to constrain it and to transform it. The problem is that it wears out, it weakens, and it cannot answer the requests that are made to it. And utopia is the engine of disenchantment that it wants to fight. And of course, there is the instrumental version of transparency at the service of democracy, at the service of integrity or exemplarity. I think that this is a distinction that is interesting, and especially to respond to the recent suggestion that Stéphanie Novak made in a book that has just been published on conflictualité dans l'Union européenne. I didn't have the time to present this idea of Stéphanie Novak. She's a politologist in France, and she studied the way decisions have been made in the Council of Ministers of the EU. And she thinks in terms of democratic responsibilities or accountabilities. And it's clear that to comply with the demands of political accountability, it is important to mention all the different positions that have been mentioned by all the different parties. And she's in favor of the permanent representatives preparing all the decisions of the Council to increase the democratic accountability of those actors. If not, the decisional process would be a failure. So if the consensus is presented to citizens as a result of a process that was taken part behind closed doors, that cannot allow them to adopt them. But the democratic process demands that the citizens know who defended what position during this debate. So I have a lot of admiration for Stéphanie Novak's efforts, and I thought, okay, this is the ideology of transparency. In the end, we don't care, in fact, if but through an excess transparency, the decisional process within the Council of Ministers is almost impossible. What is essential is transparency. So you may disagree with that. I realize that I'm taking some clear stand here, but I think that too much transparency kills transparency, and so maybe we should accept some pockets of confidentiality temporarily, and in the negotiation we turn on the lights, and transparency is required for motivations and so on. Now, the questions by Julien is very interesting. The equivalent of the principle of the separation of power at the European level, that is the principle of institutional balance, would force us to be shy, to have some reservations, as Koen said, for the Council of the State, for the codes of ethics of the different Belgian assemblies. So when I read the recommendations of the group of 10 personalities who want to complete transparency rules, to set out a European Integrity Commission for sanctions and investigations. In the 10 personalities, I don't know whether there was a specialist of the EU institutions, because it didn't happen by chance that the European Body for Integrity, which was set up through an interinstitutional agreement between the Council, the Parliament, and so on, has very limited powers, because on the principle of institutional balance, to respect the competencies of all institutions, this body is very limited in its powers. But it is recommended that this body has some sanctions in their powers. So I want to say, yes, let's do it, but that means that we would take some freedom with the institutional principles, and the people in charge of the European institutions try to block this increase of power of this body. As for the comparison with the checking of powers, it's clear that if you give this decision to a parliamentary assembly, there's always a risk that political stakes will be at play. And at the time I examine the case of Mr. Combet, this decision was not understandable, and there were political stakes at play, of course. But there is a difference with the issue of power checking, and there are some political positions at stake, and it's about sanctioning an MP. So the stakes are not the same. At the Belgian level, the only ethical commission is in the Flemish Parliament, and they were able to make decisions, especially at the beginning of its existence. During the first legislature, it was seized with 20 cases, and in 4 cases it came to the conclusion that the complaint was relevant, and they did not impose sanctions because they decided that this was an educational body, but they came to a conclusion. The second legislature, same thing. There were 13 complaints. In 6 cases, it came to the conclusion again that the complaints was relevant, and again, it's the fact that it's a political body making decisions that does not prevent it from reaching conclusions. And the Dutch model that I mentioned at the end of my presentation, I think it is interesting because it allows to bring together the external expertise and the political decision making. And I think that when external expertise is strengthened, when the external body, so the ethics committee or the second chamber of the committee of experts has some power to do an in-depth analysis, they can reach motivated opinions, and the impact of this opinion will be such that the political motivations will be less important, and it will be more complicated for a parliamentary assembly to move away from ruling provided by a group of experts, as it is the case in the Netherlands. After an in-depth investigation, they came to a motivated opinion saying whether there was a violation of the Code of Ethics, yes or no. And that can combine both elements. On the one hand, the political decision-making allows to comply with the parliamentary autonomy, and even if the assessment by external experts is such that it's more difficult to make decisions that are purely political. Would you like to answer the questions? Thank you very much for these very interesting questions. Maybe I will just take a few parts of these questions and react to what was said already. So for the link between trust and transparency, I think that this is a question we can ask at several levels. For example, at the empirical level, to know whether the laws that promulgated transparency generated more trust. And as far as I know, I think that it's hard to identify an increase of trust following these transparency laws. Second thing, when we look at the parliamentary work, so what was the intent of the regulators when they drafted laws on transparency? Then again, we find the word trust at every line. So the objective of regulations when they adopt or draft transparency laws, it's to restore trust. Why do they want to restore trust? It's because the trust was damaged by a previous scandal, so they want to counterbalance that scandal. Now, as for Professor Dumont's analysis on the European debate, I'm not an expert, but I would like to compare this with the way the French Parliament works, because the issue of the publication of the works of the different Senate group. So in 2008, we made sure that the text being discussed by the Parliamentary Assembly is the text drafted by its commission. And so that was giving to those texts a value of law. So the work of the commission was equal to drafting the law. And then it was decided to open to the public the works done by this commission, because they are drafting the law, and we consider that there's a higher greater general interest to publish the works of that commission, and the Senate tried to resist. And they're always a bit reluctant to publish the results of their work with the justification that it would prevent to reach compromise. But it is this greater principle. When the law is being drafted, it's public for the Parliamentary Assembly, at least in the 18th century, and this prevailed, including in 2008. Second thing, concerning the parliamentary autonomy, and again, the question was asked about the European Parliament versus the integrity of the representatives, or basically, despite the autonomy of parliaments, can we have a stronger policies to guarantee the integrity of the representative, of the MPs? But my neighbor will correct me if I'm wrong. The parliament that went further is the House of Commons, where after the scandal of expenses, they set up an independent body to check the status of the British MPs, and there was the notion of their remuneration. So if there is one thing that is part of the financial autonomy of the chamber, is the remuneration of MPs. And so it shows that even in traditional parliaments, when there is a political will linked to a scandal, which was a huge scandal, then there are some ways to go above the separation of powers and parliamentary autonomy to set up some checks and controls bodies to be more efficient than just the self-checking system that we find in some parliaments. Third thing, when it comes to integrity rules we can impose to politicians, shouldn't we have a constitutional reform? That's another way of asking the question. So basically, to go further, couldn't we reform the constitution, and how should we do that? You know that Bruce Ackerman, who's a constitutionalist, in his article on the new separation of powers in the years 2000, promoted a power of integrity on top of the powers we usually distinguish in the separation of powers. There should be a branch, that's the American vocabulary. There should be a branch on integrity and a branch on the protection of rights. So that's part of the thinking of constitutionalists today, that move away from the triple separation of powers to see whether there would be other branches or other powers that should be set up, and that would be an overlay or that would step over the competences of the other powers. And as for the EU, that should have more powers. Of course, there's an opposition of the political leaders of the times. You know, I rarely saw MP saying, "Oh, we're going to impose more checks and controls to ourselves with very heavy sanctions," and a check and control committee being very inquisitory for us. It's always following a scandal and the result of negotiations between the public opinion asking for a reform. And when we think that in order to calm down the public opinion, we have to say the scandal will no longer be repeated because we're going to set up some safeguards. But the activity of those proposing reforms is to submit their ideas to the public press and then to wait until there is a scandal so that this reform can be implemented. But this link between scandal and reforms in terms of integrity is highly documented in some countries. I mentioned a few examples in France, same thing in the UK, same thing in the US. The Ethics and Government Act in the U.S. Followed the Watergate, and it didn't happen by chance.
Thanks very much. Just a very interesting discussion. I've got a couple of points just to respond to. I'll come to your question in a moment about separation of powers. First of all, on the point Raquel made about the Honora O'Neill lectures, I mean, I think I have had a look at them. I think they're interesting. And I think there is something to what she's saying about cultures of suspicion being created by excesses of accountability. I struggle to go to the point where I think we've got an excess of accountability in the UK or perhaps in Western democracies more generally. What I would take from her lectures, which I think is an important but challenging lesson, is the need to think about procedural constitutional reforms in conjunction with the material constitution, and I think that's something important. So you in your paper very interestingly were talking about the importance of concepts. I think, for example, one of the attractions conceptually I think there is about responsibility as a concept is the idea that it's not just external accountability being imposed. Responsibility also implies an internalization of accountability by the participants in the practice. I think that's important. I think in many ways that's been missing in the period in the UK that I was talking about, the internal element of it. And so I think that's something that I would take away from her lectures. I suppose the other thing would be, and this is where it gets really difficult, and I don't think there are easy answers there. If you are thinking about the procedural solutions in conjunction with the state of the material, social, and economic constitution, for me, in some ways, the May-Johnson era, is it an accident that we have this undermining of norms of ministerial responsibility? At the same time, we see processes of austerity undermining the capacity of the state to respond to ineffective ways in the delivery of public services. I think not. I think there needs to be a connection understood between those two things. And so I don't think it's about less accountability. I think it's about saying we need to think about the way the state delivers its public functions in conjunction with the debate about appropriate accountability mechanisms, not one and not the other. And I think that's important because I don't think we have connected those two. I think there can be this very arid and abstract, what mechanisms of accountability can we introduce now debate, and a very separate debate about is the state delivering its public functions. Bringing those two things into conversation, I don't quite know how to do it, but I think that's an important next step. So I think that's a really interesting question. On the statutory footing of the ministerial code, and does that interfere with the separation of powers or the versions we understand it in the UK? I mean, parking to an extent the UK's discomfort with the terminology of separation of powers, which is real. I think you're right. I think the idea that taking what is primarily a political document used and enforced by political actors and legalising it to whatever extent, even if it's just legalising the fact of its existence, one of the barriers to this happening is that it's seen as blurring the lines between law and politics and the risks that it might further encourage the courts to intervene on this terrain. But in some ways, that's already happening. There was a judicial review case under Boris Johnson, brought by the Civil Servants Trade Union, into whether the ministerial code, as it is now, could be justiciable, could it be enforced in the courts. It was around Johnson's decision not to sack his Home Secretary, who'd been found by his independent advisor of bullying, and Johnson said, oh no, she hasn't violated the code and I'm not going to sack her. And the Civil Servants Union wanted to challenge that through judicial review. Surprisingly, and I think wrongly, the court said actually there are provisions of the ministerial code are justiciable if they can be interpreted by a court. Ultimately, on the facts, they said, well, Johnson hasn't really adopted an interpretation of this anyway. He's just kind of done it for political reasons, so there's no remedy. I think they were probably wrong to take that step. But it does suggest to me that if the courts are going to do that already, then what's the real risk of putting it on a statutory basis? So I think those kind of law politics divide concerns are relatively acutely felt. But I think bearing in mind, as you were talking about, the broader moves in constitutional thinking towards guarantor institutions with a kind of fourth branch outside legislative, executive, judiciary, and the kind of mixed composition that those institutions might have, I think it is something the UK should be looking at more carefully, although it seems like the political will has dissipated now. Thanks.